Thank you, Mr. Chairman. I did want to say that I understand the job impacts of pipeline construction and want to thank David Molino from the Laborers Union for joining us this morning. But I'm not asking you a question. I wanted to go ask a question of Ms. Van Rossum. Last week, Chairman Chatterjee said FERC is, quote, losing the PR battle on landowner issues, specifically regarding rehearings and tolling orders, as he announced a reorganization of the Office of General Counsel to more quickly address landowner rehearings. Now, Ms. Van Rossum, in your written remarks, you mentioned that the proposed reorganization may not address the underlying issues impacting landowners. So could you elaborate on that and what you think would be the best remedy for the tolling order issue?
Thank you very much, Congressman Pallone. First off, let me put forth the best remedy. I think the best remedy is that if there is a tolling order in play, the Natural Gas Act should be very clear that the Federal Energy Regulatory Commission cannot approve the exercise of eminent domain or any level of construction until that tolling order has been lifted on any and all parties that have a rehearing request in place. That makes sure that we maintain the status quo so nobody is put at a disadvantage. It also incentivizes the Federal Energy Regulatory Commission to comply with the 30-day time frame for responses that are actually laid out in the law. The proposal that Chairman Chatterjee put forth last week has a very significant loophole in that it says that it's going to prioritize rehearing requests from landowners, but that in all other circumstances, it will only consider rehearing requests, quote, only when time permits. So that means that organizations like the Delaware Riverkeeper Network, the Sierra Club, and others, we will still be subject to tolling. It's very important to note that some of the most important precedent-setting legal decisions that have come out in recent years when it comes to FERC and the exercise of authority have been advanced by organizations like mine, including the oft-mentioned Sable Trail decision, as well as the decision that says to FERC, this was related to the Northeast Upgrade Project further north in the state of New Jersey, that FERC may not engage in illegal segmentation and they must consider cumulative impacts when they're considering projects. Those kinds of legal challenges are not brought by property owners, and yet they will no longer be allowed to advance. So there'll no longer be a check on FERC authority.
I have to move on. I want to try to get two more in. Mr. Paris. Could you elaborate on what it would mean for the landowners on the Spire pipeline route, which is already in service and flowing gas, if a court ultimately ruled that FERC did not do an adequate need analysis? And 1 minute, because I have to ask the third question.
We've asked the court to vacate its certificate, which would mean that the pipeline has no right to be on their land. I'll leave the legal process to the state process, to state law in Missouri and Illinois, but I would imagine that those landowners would have every right to eject them from their land. I doubt that they would ask them to pull the pipeline up, but I think they would be able to retake their land and use it the way that they intended to.
All right. Then my last question is from Ms. Danis. Do you believe that FERC is providing adequate opportunities for landowners and other individuals to participate in the public comment period prior to a project's approval?
I believe that FERC has a lot of mechanisms in place for what they consider to be public participation, but it can hardly be said to be real public participation in a meaningful sense when there is no opportunity to have any kind of an evidentiary hearing or to examine the data that's in the record. And as far as the public is concerned, the only economic analysis the public is given is the precedent agreements. And the commission does not disclose its balancing inquiry until the moment it issues a certificate, and at that same moment simultaneously denies, for example, a motion for a request for an evidentiary hearing. So the public can submit comments. It is unclear to me what value, if any, the commission places on those comments because 99% of projects are certificated over serious landowner and public objection.
Okay, thank you. Thank you, Mr. Chairman.